So good morning, really, and a formal welcome to the Human Rights Institute's CLE, Racial Justice, Restoration, and Inclusion, Human Rights Principles, and Local Practice. I'm JoAnn Kamuf, and I direct the Human Rights in the US project at Columbia Law School's Human Rights Institute. And it's really my immense pleasure to welcome all of you to today's event. I am deeply disappointed, of course, that we are not able to do this in person as we initially planned, but I'm thrilled to be in community with all of you, at least in this way, as we gather for what is the Institute's 17th annual Symposium on Human Rights in the United States. We, of course, are coming together at a time when the need for solidarity and for community couldn't be clearer. I think we're also in a moment that exposes us to the really deep need for a new approach to policymaking and governance, one that promotes equality, centers dignity, and which really reckons with the historical and ongoing discrimination that permeate all aspects of American life. It's essential, too, that we prioritize societal repair because it's clear that the social contract that we all need and which we deserve is broken. Today's program is designed to inspire new ways of thinking about legal work and advocacy, which takes these principles into account. So for the next few hours, we're going to explore together how a human rights framework, a set of universal standards premised on equality, justice, and accountability, can enhance our collective work towards racial justice. According to human rights norms, which includes treaties ratified by the United States, federal, state, and local governments have obligations to prohibit and eliminate all forms of discrimination. That includes eradicating laws and policies that perpetuate bias and discrimination. It includes ensuring economic and social rights. And further, governments must provide redress when human rights are violated. Today, we'll learn how organizations are leveraging rights-based strategies to shine a light on and disrupt laws and policies that perpetuate inequality on the basis of identity and status. And we'll examine advocacy that pushes the boundaries of how we define justice, how we shape remedies, and how we promote reconciliation and restoration. Our discussions will draw from global principles and practice, national advocacy, and local initiatives as well. And in line with the Institute's longstanding focus on human rights implementation at the state and local level, we're going to highlight the role that city government can play in fostering equality. And the Human Rights Institute is really proud to host this event and privileged to have a wonderful group of co-sponsors for today's program. That includes the Center for Constitutional Rights, the CUNY Law School Gender Justice and Human Rights Clinic, the Leadership Conference on Civil and Human Rights, the New York City Commission on Human Rights, Northeastern Law School's Program on Human Rights and the Global Economy, the US Human Rights Network, and from Columbia Law School, SJI, and the Human Rights Law Review. I would really also personally like to thank Dana Sussman, Martha Davis, Cindy Suhu, and Nahal Zamani for their partnership in shaping the program for today. And a really personal thank you to HRI's Maya Al-Khateb-Chami, Jessica Pearson, and Dominique Gallo, who have done a ton of work in the background, including right now, to make sure that this program is a reality. And also thank you to the Columbia IT team who's on the line. I'm really excited about today's conversations. I'm excited because we're going to hear from advocates who are building innovative remedies into their work to seek accountability for past harms, including in calls for reparations. Excited because our discussions will highlight how restorative justice principles are being implemented in my hometown, New York, to improve health, to keep families together, and to innovate in and around our court system. And I'm excited because together, those of us in this program, but also our networks, have the power and the potential to push forward transformational change. The current pandemic has given governments, including our own, new cover for policies that marginalize communities most vulnerable to economic and social harm. COVID-19 has also shone a spotlight on the deep injustice that results from structural discrimination and from a failure to design policies to meet basic needs. Of course, the injustice long precedes the arrival of the virus. But today there's renewed attention to the importance of systems and policies that provide a social safety net for all. Amidst the pandemic, we see renewed momentum to address longstanding disparities in health and economic and social supports. And we see solidarity across movements, even though critical tools of organizing have been removed. As we speak, workers and renters across the country and in New York and around the world are striking and mobilizing for greater legal protections. So while we'll certainly hear about deep and persistent barriers to equality today, we will also hear about pathways being forged to make human rights a reality. Our keynote speaker, Margaret Burnham, will discuss why the turn to human rights is relevant for us in this moment and how we can reckon with some of the past harms that got us where we are today. During our first panel, we will learn about efforts to leverage human rights standards and engage with the inter-American human rights system to ensure accountability for racial injustice. And this will include efforts to secure reparations, including acknowledgements of past harms and compensation. In our second panel, we'll learn about initiatives that center the experiences of individuals most impacted by human rights violations in order to transform systems so that we improve health, foster family unity, and deliver justice. Throughout these sessions, we'll talk too about how to elevate the work happening across the country and the particular role of lawyers. And for the attorneys in the room who are seeking New York CLE credit, just a reminder that you will need to submit an evaluation and attendance verification form with the course codes that we will announce during the program today. And those forms are on the event website and will be emailed to you. And for everyone that's participating, if you want to tweet today, you can use hashtag CLE Race and Rights. And you will have the ability to submit questions during the panel discussions using the Zoom Q&A function. Today's program is just one of the ways that the Columbia Law School Human Rights Institute works with lawyers and advocates to cultivate human rights implementation to advance gender, racial, and economic justice in the United States. We also coordinate the 900+ member Bringing Human Rights Home Lawyers Network, and it's really a great honor and privilege of mine to be able to work with many of you on an array of initiatives to strengthen human rights protections here at home. The United States has never fully embraced human rights principles in law or in practice under any administration, but I believe together we can change that. So to help us articulate an affirmative vision and identify forward-looking strategies, we're honored to have a remarkable group of speakers and audience members from around the world today. And without further ado, it's really my pleasure to launch into the program and to introduce our keynote speaker. Our keynote speaker directs the Civil Rights and Restorative Justice Project at Northeastern Law School, leading efforts to seek justice for violence and discrimination in the US, particularly in the US South between the 1930s to the 1970s, using litigation and restorative justice models. Her storied career has been marked by many accomplishments, and I will highlight just a few. Our keynote launched her career at the NAACP Legal Defense and Education Fund and was the first African-American woman appointed to the bench in Massachusetts. She worked in private practice for many years as well. Notably, in 1993, South African President Nelson Mandela appointed her to serve on an international commission to investigate alleged human rights violations within the ANC, the precursor to the South African Truth and Reconciliation Commission. She's an expert on comparative constitutional law, international criminal law, and human rights. So it's my pleasure now to turn it over to Judge Margaret Burnham, also a distinguished law professor. Thank you.
Thank you very much, JoAnn. It's an enormous pleasure to be here and an honor to join the network and be part of this fantastic faculty, which includes my old friends Wade Henderson and Monifa Bandele. It's an enormous pleasure to be with you, grappling with questions that are both urgent in the age of Corona, as JoAnn has said, but also at a slight remove from our daily check-ins on the health of our loved ones, on the shape of the curve, on the progress of the vaccine, and on the hitherto hidden virtues of bleach. I especially thank my colleague Martha Davis, who, along with many of you, initiated this movement to bring human rights home well over a decade ago. And for that far too generous introduction and her leadership of this program, I also thank JoAnn Kamuf Ward. It's wonderful to be back home in New York, even if only virtually. And it's especially nice to be here on May Day. I'm a proud graduate of PS 20, Francis Scott Key Junior High School and the High School of Music and Art. So it's really terrific to be back in the city, and to tell the truth, it's the only reason I signed on for this event, because JoAnn promised a restful ride on the Acela Express and a very nice Midtown hotel. So since I can see my refrigerator out of the corner of my eye, I don't think I'm on 53rd Street. JoAnn, you owe me, and God willing, I'm going to collect one day on that.
I do. I owe you. I promise.
Boston strong, New York tough. You heard it here first. So let me say a few words about our work at the Civil Rights and Restorative Justice Project, and then I want to describe the connection between that work and the human rights normative framework within which it is situated. Our project, which is now 10 years old, aims to excavate and explain the history of racial terror during the Jim Crow era. The work is around organizing an archive of cases of racial violence from racial homicide from 1930 to 1970. Our students and staff pick apart each of the cases. We have over 1,000 cases, and we examine the associated legal, historical, and economic issues. And then we work with the families on restorative justice projects. Ultimately, the data and the documents will be available to scholars and researchers and to the wider public. So we are scholars who practice and practitioners who depend on scholarship to inform our work. Last month, our team met in Birmingham with the mayor's office and the police department to share our research on Jim Crow era homicides, police homicides in that city. Our students had compiled a file of every Jefferson County, that's where Birmingham is located, police killing from 1939 to 1968. Let me show you exactly what they found. So what they found here were killings by police officers over the period of time 1939 to 1968. There were 140 killings, and of those, 136 were African-American men, and 2 were African-American women, and 2 or 3 were white men. You'll notice at the bottom of the chart, there were no white women killed during this period of time. In one year, 1948, there were 16 Black men who were killed. No white men at all were killed during that year. And this is in a county that, excuse me a second. This is in a county, Jefferson County, that during this period was slightly less than 63% white and 37% Black. So also significant was the students finding that several of the officers who committed these crimes were repeat killers and had suffered no job consequences. In one case, the one officer was promoted after killing 3 African-American men. The same coroner looked at all of these cases, and in virtually every one of the cases vindicated the officers. So this research has taken us in 3 directions. First of all, we are supporting the initiative of people in Birmingham who at the local and local level and public officials there in Birmingham are designing a truth-telling process to engage with this history. We're also facilitating community building among the descendants of the victims and supporting their individual RJ projects. And finally, we're designing training materials for use by the Birmingham Police Department to introduce their officers to this history. Ours is one of several projects that have emerged in recent decades that seek to apply human rights discourse and practice to the US historical wrongs. And what I want to focus on here today is that murky intersection between human rights discourse, conceptions of justice, and historical wrongs. I don't want to sound too cliff notey about my presentation, but I do want to discuss quite clearly what transitional justice and restorative justice and reparative justice have to do with the civil rights practices, civil rights and social justice work that we do here in the United States. At the end of the day, as John Rawls once said, it is all about justice because it's through the lens of justice that we discern whether the gifts of humanness are more or less equally accessible. To Rawls' rule that justice is the most salient measure of a society's success, human rights theorists and practitioners have added specific models and concepts of justice and tools to achieve it. Prominent among these models are transitional justice, restorative justice, and these models borrow from a toolkit that includes truth-telling processes, memorialization, and apologies. Some of the models also employ amnesty, lustration, prosecution, retribution, and reparation. International law and human rights institutions have codified and fostered the dissemination of norms to support these concepts of justice, which include the right to truth, the right to of witnesses to be protected, and also the right to some form of restitution or reparative justice. So I want to begin with transitional justice. As one scholar, Christine Bell, noted in 2009, transitional justice is not so much a discrete field of justice as it is a sphere of practices and theories about justice, state power, and regime change, practices and theories that borrow from a number of fields, including law and political science. In general terms, transitional justice are those state powers and policies and practices that shepherd authoritarian states or states emerging from war or conflict toward a democratic human rights respecting regime. Albie Sachs famously used the bridge as a metaphor for the long walk toward regime change. Up for grabs is whether the bridge will collapse, the walkers will push each other off the bridge, or some other mid-journey catastrophe will interrupt the transition. The main objective here is to bring as many people as possible to the other side, while at the same time designing a new stable regime. Transitional justice practitioners are concerned also with what's happening on the bridge, because the practices that guide and grease the way to transition are also going to determine relationships, state to citizen relationships, neighbor to neighbor relationships, victim to perpetrator relationships, in the more just regime where constitutionalism, dignity, and equality presumably are going to matter more. But as a functional matter, the overarching purpose of the tools in the transitional justice toolkit is to render a successful transition. So it's pretty obvious that the tenets of transitional justice do not line up neatly with what we here in the United States are doing. Many commentators argue that transitional justice doesn't apply in states that have long classified themselves, at least, as long-standing democracies like the United States and Canada. So, for example, while Canada has engaged with truth processes to address its legacy of a settler colonial, the legacies of a settler colonial state, and to address the harms that have been visited upon its indigenous communities. Unlike the South Africa Truth Commission, these initiatives, although they borrow from the Transitional Justice Toolkit, do not fly under the banner of transitional justice. Rather, these reparative measures are described as the politics of amends or state redress. Transitional justice requires a demarcation, an identifiable break between the past and the present, or to put it another way, a reason for the rupture and an aftermath of the reconciliation. As helpfully described by the political philosopher Colleen Murphy in her book, The Conceptual Foundations of Transitional Justice, when four factors are present, one can say that transitional justice is in order. First, inequality that is profound and structural in nature. Second, normalized, widespread wrongdoing against an individual or community perpetrated or sanctioned by the state that is often political and particularly brutal. Third, serious uncertainty about citizen-state and citizen-citizen relationships. And fourth, fundamental uncertainty about the nature of authority if the transition should be successful. To these four, I would add a fifth factor, and that is global condemnation of the human rights violations. So as applied to the Jim Crow period, it is manifestly the case that all of these factors were present until the civil rights movement of the 1960s. Plainly evident as well is that at least the first two factors fully characterize the world that we live in today. Deep economic cleavages continue to operate on race lines as witnessed today, the corona health gap, and the second factor as well, while obviously more condemned than in the past, race-based wrongs indisputably continue to be perpetrated and sanctioned by the state. So by way of example, to return to Birmingham for a moment, a lawsuit filed just a few years ago by an old colleague of mine, U.W. Clement, challenges the decision of white city councilors in a suburb of Birmingham to create their own school district in order to screen out Black kids from Birmingham. U.W. Clement's work was featured in a New York Times a couple of years ago, and he recounts his 40-year battle against school desegregation and against school segregationists in Birmingham. So while it's not quite as palpable today as it was during the civil rights era or in the South African context at the height of the anti-apartheid movement, the proposition that we are about to turn a corner and on the other side, there awaits a bleak futurity of opportunities really does not fully describe our situation today. The US is not where South Africa was in the 1980s or in the early 1990s. It's not Colombia winding down 50 years of conflict between the state and FARC. It's not Argentina as it emerged from military rule. We don't face, as Rudy Titel described it, that, quote, rare moment of rupture, which offers a choice between contested narratives. The racial chasm, the wealth gap, the education gap, all of these things remain largely unmitigated, but despite these ongoing disparities, we're not the pariah state we were during the Jim Crow era. We might be a pariah state, but not for those reasons. And we may be poised at a precipice, but it's certainly not that one. And so the uncertainty that Murphy describes is characteristic of the transitional moment, not knowing whether what the new order will mean at a personal level, whether one will benefit or be harmed by the new dispensation. Literally, whether one will survive the transition with limb and life intact and loved ones and poverty secure. This acute anxiety and terror, really the sense that life is cheap, all of that is the everyday partner of thoroughgoing political transformations. And that's absent in the US current context today. Of course, an argument could be made that nevertheless, when Black men of a certain age step outside of their houses, they do take their lives in their hands in the same way that those 140 men in Birmingham did in the 1940s and 1950s. And as well, when an indiscriminate virus hits a racially skewed system, premature death, to borrow a term a term given us by Ruthie Gilmore, will discriminate with vicious regularity and lethality among some of us, but not others. So in what ways then does transitional justice as a modality of governance advance our work on historical justice here in the United States? Here I want to go back to Birmingham for a moment and say a bit more about why those 140 police killings from 70 years ago matter. Jim Crow in Birmingham, as elsewhere, was comprised of two complementary systems of racial hierarchy. On the one hand, Jim Crow functioned to mobilize race to build white wealth in the industrialized South. And on the other hand, Jim Crow resorted to containment and criminalization to manage and control Black life once the coal and steel mills pulled people away from the plantations. The police file that we discovered and unpacked demonstrates these separate strains of Jim Crow injustice, individuating them and thereby revealing the inexorable link between Black subordination and the accumulation of capital. As well, it reveals uniquely and specifically the dynamics and costs on both collectives and individuals of police violence, taking us beyond the hackneyed and mythologized images of the segregated streetcar and Bull Connor's dogs. It historicizes our contemporary experiences of police violence, enriches our understandings of Black struggle, and rejects the Western movie set approach to racial history that depicts a static, a yesteryear, and a laid to rest past. It allows us to absorb the individual event as well as the structure. It reveals the all-encompassing, unrelenting, grinding impact of state violence on Black lives, unmasking a violence that was not contained in the street or in the field or on the home or the police station, but rather it was regenerated in everyday lives and everyday spaces. In sum, it gives the lie to the dominant narrative and puts in its place the factual architecture with which to engage a constructive dialogue about the past that is based in truth. A truth project addressing this history is not really about history. It's about the present in discourse with the past. It's about intergenerational trauma, unrelenting and ongoing vulnerability, precarity, and lethal inequality. So when we excavate with these stories, we do so in order to establish and reinforce and reinvigorate our memory, and working within the parameters of transitional justice, that therefore we shift these more accurate understandings of history to the adversarial arena of claims, pressures, and current demands that impact and should impact the world that we live in today. We can and we do debate whether we meet the criteria for transitional justice as set forth by Murphy or others, but some things are not debatable. Even if the legislative reforms of the 1960s marked something of a break with the past, it's clear that it was on many levels and for many reasons an incomplete, if not failed, transition. First of all, even if one measure of the success of liberal democratic reform, if we take liberal democratic reform on its own terms, the 1960s laws fell far short of what was needed to stem terroristic racial assaults. As I argue elsewhere, when it adopted the Civil Rights Act of 1964, Congress could have protected what I call justice rights, the right to be free from racial violence and from discrimination in the administration of criminal justice. As a matter of fact, John Lewis urged just such a provision from the steps of the Lincoln Memorial in August 1963, but Congress failed to act. Congress would not confer power on the Justice Department to address racist policing with civil enforcement powers until 1994. Secondly, the legislative initiatives were forward-looking and did nothing to address these past systemic harms. And finally, the massive structural injustices that were based on the imperatives of capitalism were left untouched by the civil rights achievements, significant though they may have been. In sum, there was not and has yet to be a transition from the Jim Crow regime. The US is a non-transitional regime, and the civil rights movement was not successful in challenging racial capitalism as the underlying cause of human rights violations. And so we need to demand, as many are doing, this full accounting. And so while we're waiting for that, as my Birmingham example teaches, I hope, the essential themes of transitional justice as reinforced by human rights instruments, perhaps most prominently by the Special Rapporteur de Grief's report in 2017, as well as the current Special Rapporteur on the right to truth, to memory, to guarantees of non-repetition. All of these offer a framework within which to combat amnesia about the past and to anchor contemporary struggles for justice. I want to say a few words about, in the time I have left, about restorative justice and reparations, two other perspectives on what constitute just relations between individuals and between the state and the governed. In contrast to transitional justice, which at the end of the day is a state-sponsored project, restorative justice is defined as much by what it rejects as by what it is. Retributive justice, the notion that wrongdoers should suffer proportionate consequences, are rejected by restorative justice practitioners who instead focus on repairing harm, reintegration, non-repetition, and acknowledgement. In our work, we conceptualize the social healing is the central organizing principle of restorative justice. And we call our work restorative justice in as much as we're trying to restore a sense of justice and to use historical memory to restore dignity to victims of historical harms. The work is restorative because it seeks to repair the harm. It centers the experiences and needs of the victims. It insists on genuine accountability and seeks to return the practice of conflict resolution to those primarily affected and who can affect meaningful repair, namely the communities of care of victims and offenders and the larger affected community. So we do find we need to shift the restorative justice praxis in order to open up a space, however, for righteous rage, resentment, and distrust. The challenge here is to perceive and to treat our clients as individuals who have suffered wrongs and not just as victims of the system that we're trying to dismantle. So in our work, we acknowledge the deep anger and affirm deep anger as the appropriate responses, not only appropriate responses, but responses that register as political consciousness and emotional well-being rather than as indications of psychic damage caused by racial trauma. So I'd like to turn in the few minutes I have left to reparations, which of course is a component of transitional justice. But while the Transitional Justice Project addresses the need, does address the need for material restitution, as understood in our context, reparations is necessary to redress historical wrongdoing, whether or not the restitution leads to a definable and clean break with the past. And I'd suggest here that the failure to elaborate a full and common set of principles with which to assess reparations claims associated with past wrongs like settler colonialism, settler colonialism, slavery, and Jim Crow is itself a reflection of the inherent limitations of a human rights regime that is based on liberal understandings of individual rights. So we can and we should debate who should give, who should take, and how much with respect to reparations. But the reparations demand is on the table, has been since 1898, with the initiation by Callie House of claims for reparations for ex-slave, and that demand is only going to grow stronger and those of us who are working in the civil and human rights arena need to figure out how to relate to the space and to amplify those claims. So one might well ask why something beyond an apology is owed to our 140 men in Jefferson, and the 2 women in Jefferson County. And certainly, as we engage with the mayor and city councilors there, they do ask, are you talking money? So, should the victims, the beneficiaries of reparation for Jim Crow harms be identified by their relationship to a specific injustice like police crime, or are all African Americans who endure Jim Crow, is their African American identity sufficient for reparations? We could ask whether the harms these families suffered can be disentangled from the centuries-old history of racial justice. We could ask by what criteria the rightful claimants are to be determined, from whom reparations is owed. Are the counties, the states, the federal government, the perpetrators, the other complicit individuals to be looked to? We could ask by what scale is the relative responsibility of those who benefited from the wrongdoing to be calibrated? All of these are legitimate questions that demand and call for further exploration. I also think that a theory of reparations has to respond to the critique of Afro-pessimists who view reparations as politically reactionary because they say that it more deeply consolidates an ideology of racial capitalism and offers false hope for relief from scarcity and precarity. And I recognize and respect those terms and those arguments, but I think that reparations is a longstanding claim that needs fully to be integrated with feminist and Marxist expressions of freedom, understandings and expressions of freedom and political participation. So my time is drawing to a close. I have more to say about reparations, but we do want to keep on schedule here. What I will say here is that there is enormous work left to be done to align human rights principles with these claims that are based on historical injustice, whether the claims sound in transitional justice or restorative justice or in reparations. Obviously, we are meeting at a time in our lives when our own personal lives in our country are under enormous strain, and we're enduring also racist and bellicose assault from the White House and elsewhere, an assault that favors myth over fact and fantasy over history. But never mind all of that, our work goes on, and as we continue to sharpen our tools and add to our toolbox, we continue to look at global developments on the human rights arena to advance our own claims. Thank you very much for the space and the time.
Thank you so much, Margaret. I know that I'm speaking on behalf of lots of people because they're messaging me right now to say that thank you so much for those powerful remarks and for providing a normative scaffolding for the conversations today, thinking about the overlaps, but also distinctions between transitional justice, restorative justice, and notions of reparations, all things that we'll return to in the 2 panels that follow. I also wanted to thank you for recognizing and validating, I think, the righteous rage that many of us are feeling in this moment, and for emphasizing some of the limits of the individualized approaches that we have historically taken within our justice system. And finally, for pushing us all to continue to engage in this project of truth-seeking and truth-telling, which is clearly essential for all the reasons that you mentioned.